The notice says this administrative investigation is of potential violations of LSP and or DPS policies. The investigation is in regards to a potential violation of the performance of duty policy during a DWI arrest that occurred on March 24th, 2021.
Okay, so he knew the date of the occurrence had happened, correct? He knew that it was regarding a DWI arrest on that date, and from, I believe, you said he had 2 arrests, I guess, that day, correct?
2 traffic stops.
2 traffic stops,
Yes.
1 arrest. So one was just a traffic stop.
Well, he pulled 2 cars over simultaneously.
Gotcha. 2 cars over, but only 1 was the DWI, correct?
Yes, ma'am.
Which is listed in the letter, correct? So he knows that, yes, I may have stopped 2 cars, but what this is about is the one that I arrested for the DWI, correct?
Correct.
Okay. So he knows date, he knows what arrest it is. What other information would he have needed to prepare? Because at that point, he knows that we're talking about this arrest on this date, and this time it was this DWI. So what else would he have needed to prevent this issue that
He would need to know the substance of the factual allegation. In other words, if I were to ask you, and you don't have to answer, not your role. I'm the one that has to answer questions. I get that. But I would ask you, well, tell me, based on that, what do you think he was being in trouble for? What do you think he was being investigated for? Was it the stop? Did they think the stop lacked probable cause? Did they think he was unprofessional in the way he dealt with this individual who claimed that his uncle was the chief of police somewhere? Did they think that he made a policy violation for stopping 2 vehicles simultaneously? Because it says violations of LSP and or DPS policies. Well, how many of those are there? I mean, throw a dart at a board and try to pick the one. Was it the way that he interacted with? Was it the way he performed the field sobriety test? Was it? I mean, I could keep going every step of it. So, what? That's a lot of issues in there, and I can tell you what it ended up being if you would like to know.
I'll get to that in a moment. So in regards to that, ma'am, I think you did specifically say that in regards to, you listed the 2 chapters that it was alleged violation, but you did list the actual potential, what was it, a neglect of duty? What was it again?
The specific policy, it was listed as performance of duty.
Performance of duty. So that policy, so you know what policy it was. They did say what policy that he allegedly violated, and it was regarding that DWI stop. So again, he knows what stop he was looking at, that they're looking at, and that it was performance of duty. So in recollection and preparation for that, what prevented him from recalling that event or his actions that day to prepare for this day?
Well, he had no idea what the allegations were. I mean, there's a lot of he was with this man for 3 hours probably. So the performance of duty policy could almost mean anything in any situation. But your rules don't say that to be provided notice of the incident. It says the factual allegations. There's not a court in America that would regard this notice as providing factual allegations. It wouldn't pass muster in any court that I've practiced in front of in 25 years. And I bear to say it wouldn't pass muster in front of any court any of these other attorneys have practiced in front of in their career. But what would be the harm? My question rhetorically would be, with the state police adhering to your rule and saying, okay, tell them what are the allegations. Allegations are, we allege you did this in violation of the performance of duty policy. That's what we allege. We allege that you did this and these allegations violated this policy. And the trooper says, okay, well, I can prepare for that. I can come sit and I can be questioned on. I can walk in and prepare. So what's the advantage to the department to have the trooper prepared? What's the disadvantage to have the trooper prepared? What's the advantage to have the trooper unprepared? You know, I mean, these are your rules, and I can't stress that enough. And y'all said not the incident in question, but the factual allegations being made. And that's all we're asking.
Colonel Davis here. I just want to assert that upon notification, the trooper still has access to their body-worn camera. They still have access to their reports in which they still have access to all of that information, as well as to their supervisors who possess the knowledge in which they can offer them advice and such. We do not restrict that. So his preparation at that particular point in time is based upon his initiative and going in and reviewing the body-worn camera, reviewing the policy, and reviewing those things that are available to him.
And that was my next question, Colonel. Thank you for offering that information up. Was once this notice is served, did Trooper would have access to his body-worn cameras from that event so that it could be reviewed in its totality by him in an effort to prepare for the statement, to which you've already answered that, as well as are they allowed to consult and talk with their supervisor, any reviewing paperwork, arresting paperwork, or anything? And I'm seeing shaking heads from the opposing team.
His body camera
Well,
was
let me let
blocked.
the colonel reply to me first, and then I can see, okay?
Thank you, I'm sorry.
Colonel.
I do not authorize anyone to restrict body worn camera footage from Woodward. So, to my knowledge, it was not restricted from him. Additionally, if he feels that there is some qualifying or additional information he'd like to provide, maybe some recollection after the initial interview, he has that opportunity to come back and also provide that information as well.
Okay, thank you, Colonel.
Well,
Yes, sir, now go ahead.
yes, the colonel was not aware, but Trooper Woodward was blocked access to his body worn camera, number one, by someone in the department who had authority to do that. I don't know if he even knows, but they typically and routinely do that. Second, their very notice says that he's to keep the substance of the investigation and the fact thereof confidential. Okay, then it says that ongoing administrative investigations are considered confidential, and as such, officers shall not violate that confidentiality. Those in violation are subject to disciplinary action. Then it says an employee shall keep the nature and or details of the IA investigation in strictest confidence. So if he goes and starts talking to all his coworkers, he's got another IA charge. So, but the problem that I have with the administration's proposal today says, look, we're just going to give them the incident. They can go look at all this and maybe they guess right. Maybe they figure it out what we're here for. Maybe they don't. But they can go try to figure it out, and maybe they do, and if they do, then great for them. That, again, is not what the law says. The law says that the administration is to inform the trooper of the substance of the factual allegations being made. I'm not asking for anything more than what this commission promulgated.
Mr. Chairman,
Yes, sir, Commissioner Muir.
it's a balancing act for the department. For example, once they start an investigation, they have to notify the employee that it started. Okay. At that point, they don't have all the facts. They haven't reviewed everything. So if they wait to do the investigation and then notify the employee, they're breaking the commission rules in regards to the investigation. I understand it is stressful to be investigated, especially for LSB policies in general. But as an employee, you're required to follow all policies. So in that investigation, if they ask you about a particular policy that they feel that in the arrest that you didn't follow, then you have an opportunity to answer if you did or did not follow that policy and why. You know, the policies are there as a guidance. If there's a reason why you don't follow that policy, there is an opportunity to explain why. And if the department is reasonable, as it should be, in regards to you disregarding a policy, you have an explanation for it, then so be it. But just because you're asked about a particular arrest in regards to policies, I don't see how that they're adversely affected.
Okay.
They're stressed, but you're getting paid, and there's no adverse effect, in my opinion, as an employee.
Then please amend the rule and take that out, because the rule creates the expectation that it means what it says. Just take it out, take out the ones you don't really mean to enforce. But I disagree, Mr. Meyer. By the time they issue this notice, they think the trooper did something wrong, right? They don't issue administrative investigation notices and schedule interviews because they're still investigating. By the time they sent this letter, they believe that Trooper Woodward had violated policy. They've been alleged for potential violations of policy. They've been alleged the performance of duty policy. So at this point, to say that they were prohibited from setting forth the factual allegations is not correct. They had what they believed to be the violation. They knew well the violation at the time they issued this March 31, 2021 notice. And there's nothing that would prohibit them from saying, we believe you violated by the following. And there's nothing in the record to suggest that they were still investigating it up until the time of his interview. They could even amend the notice if they gather more allegations. But this body has said that the troopers are entitled to know what the allegations are. And either admit it when it passed it or it didn't. It's that simple. I mean, it's really not a complicated question. We can come up with all the excuses, but y'all passed a law that says that they shall inform the troopers of the allegations being made. And they did. And we're asking you to say, look, you gotta do it in the future. You can't redo it in this case necessarily, but in the future cases, this is not sufficient.
Mr. Chair.
Yes, sir, Commissioner.
Administrative counsel, let me ask you this. At the time of the filing of the notice, and as I read the rule, when it says the substance of the factual allegations, obviously there was a factual allegation alleged that caused you to file for the investigation, correct?
I assume so, yes, sir. Yes, sir.
Not an assumption. I mean, something had to be alleged for the investigation to be brought forward. So I'm assuming. So if the rule says that the trooper is under investigation, including the dates of the alleged offense and the substance of the factual allegations being made against the trooper, is it the administration's position that just by stating that the performance of the duty violation is that substance?
Yes, sir, it's our position that we did comply with.
Okay, let me ask you this. At the time you filed the notice to notify the trooper, did you have additional information on the specific allegation that was being made against the trooper that caused you to put forward the notice of investigation? And if you did, why did you take the position not to include that in the notice?
If I may, oftentimes when we get initial allegations,
Sure.
oftentimes it turns out to be something different or another policy violation.
Sure.
We take what we have at that particular time, and that's what we serve as notice. However, that's not conclusive. So for us to say we had all of the information, that's why we were conducting the investigation. What we typically have at that particular time falls within the realm of saying this is something that leads to, in the criminal side, we said probable cause, but we have enough information to indicate that something transpired and it falls within the realm of this policy.
Right.
That's all we know at that particular time.
I understand that, but I want to be very clear. I'm not saying that the allegation is factual. I mean, the allegation that was filed according to the rule is a factual allegation. I'm not saying you're concurring with the allegation when you initiate an investigation. You're just simply saying this is the allegation made before you. I'm trying to figure out if that allegation had been made, Officer X is being alleged to have done this, which violates this rule. You're not saying that this is what happened. You're just saying because of this allegation, we're launching an investigation. I mean, I was a fire chief for a number of years in a municipal, complex in Shreveport. I went through hundreds of these. And I can tell you that when we issued a notice of investigation, we always listed the rule violation and the specific allegation that was being made so that the individual firefighter could prepare for that defense. So I do have a little bit of a challenge with if you had a specific allegation, which you would have had to have, not saying you concur with that, not saying you agree with the allegation, but you have something that started the investigation, that information should not be provided to the trooper to allow them to prepare for when they do, when they are interviewed, they know what they're being interviewed about specifically. So I'm just trying to determine if that allegation was something that was withheld. Did you have it? What initiated this investigation? Not agreeing with it, but there was an allegation. And the rule says if there's an allegation that you provide that in the notice, what you have at the time, and understand Trooper Mears' comments, but if you have an allegation at the time, you're not saying that, hey, we've completed our investigation, we agree with this, but hey, this is the allegation. We're just letting you know we're investigating the allegation. Some other rule violation may come up in the course of the investigation, but this is what we have right now. I think that's fair. I think it's a fair question. So.
And if I can address that,
And
then-
Hold on just a minute. Still talking to the administration.
Sorry, thank you.
So, I wouldn't say that we withheld an allegation. We felt that the notice that was provided was sufficient to comply with the rule and sufficient to allow Trooper Woodward to prepare for his interview because he was aware of which arrest it was, he was aware of the date he was aware of the policy.
But that doesn't talk about the potential violation. That doesn't talk about the allegation, which is specifically cited in the rule, that you shall give him the allegation. You gave him the potential rule violation of an incident, but you did not provide him with the allegation that is prompting this investigation. And I'm just trying to figure out, if you had that allegation, what would be the reason for withholding it from the trooper when you provided the initial notice? Again, it's not, I don't buy the argument of, hey, this is agreeing with the allegation, this is concurring that the administration already has convicted, this individual, but it's giving them due process. Like I said, I've been through this, and I can tell you that if I had not provided the allegation when I provided notice to firefighters in Shreveport on dozens and dozens of cases, my civil service board would have thrown it out.
Yes, sir. And before I recognize Commissioner Richardson, I do want to remind everyone, this is on a motion for summary disposition, that we're getting way into the facts of this matter, which may or may not be appropriate at this stage.
And Mr. Chair, I'm not getting into the facts of the case. I haven't even mentioned the case. I'm just looking at what we're here for this morning, and that is to look at this rule.
Right. But what they knew, what they didn't know, what they disclosed, didn't disclose. That's my only point. Let's
And I'm not asking for what it was they knew. I'm just saying if they knew what the allegation was, it should have